Good evening and welcome to Current Affairs. Who will make laws in India? So, the Constitution of India has permitted the Parliament and the state legislatures to make the laws. So, and the whole procedure is explained by the Constitution. That is the reason why. So, whenever you want to make a bill, whenever you want to make a bill has to be introduced in the Parliament, and after it is passed by both the houses of the Parliament, then it will be forwarded to the President of India, and with the assent of the President of India, a bill will become a law. In the similar manner, so whenever you want to make a law at the state level, a bill has to be introduced in the state legislatures. After it is cleared by the state legislature, the governor of the state will give the assent and a bill becomes a law. So this is a general procedure that is present in the constitution, and this is what exactly we are following. And apart from this, so in the case of very urgency, so whenever the parliament is not in the session or the state legislature is not in the session, the constitution has given extraordinary powers to the president of India and also the governor of a state. So under the constitution, under article number 123, the president may promulgate ordinances. In the similar manner, under article number 213, the governor of a state can promulgate an ordinance. Promulgation means announcement. But here, let's try to understand what exactly is the meaning of an ordinance. Ordinance is always a temporary act, and that will be promulgated by the President of India or governor of a state as per the case, only when the legislature is not in the session. So if the parliament is not in the session, then the president can declare an ordinance. If the state legislature is not in session, during the time, the governor is also permitted to declare an ordinance. So meaning is simple. This is a recess period where the parliament session is not there and the state legislature is not there. So only to meet such situations where there is an urgency, in order to meet those situations, it has been permitted by the Constitution of India. But there is a condition. Once ordinance is promulgated by the President of India, whenever the parliament session will begin, on day number one, the ordinance has to be introduced in the parliament. And from that particular day, that ordinance is valid for 6 weeks. I am talking about the validity of the ordinance after the reassembly of the parliament or after the reassembly of the concerned state legislature. That is valid for a period of 6 weeks. In the case of parliament, what will happen? Within this 6 weeks, that should be accepted by both Lok Sabha and Rajya Sabha. Then it will go to the President of India. With the assent of the President, that ordinance, which is considered to be a temporary act, will become a permanent act. Otherwise, ordinance will have the validity of a very limited period of time. Then what will happen if this ordinance is not accepted by the parliament? Ordinance is considered to be, this is withdrawn, and there is no validity with respect to this ordinance. At the same time, president is also empowered to withdraw the ordinance at any time. Governor is also empowered to withdraw the ordinance at any time. Or the concerned state legislature may pass a resolution and declare that this ordinance is not permitted. So there are so many mechanisms to nullify this ordinance. But the point is that how many times we can promulgate an ordinance? Can we re-promulgate the same ordinance again and again, again and again? Constitution is really silent on that. But when it comes to the spirit with which the constitutional framers have framed the constitution, the idea is that only under very, very necessary and urgent circumstances you are permitted to declare the so-called the ordinance. But otherwise, what is happening? This ordinance became a tool in the hands of the government of the day. In the hands of the government of the day, and whenever they want to issue any ordinance, they are doing it. After all, the President of India or the governor of a state are the nominal executives. As we all know, real powers are vested in the Prime Minister and the Chief Minister at the state level. So obviously, the Prime Minister may be advising the President of India so to promulgate an ordinance. Similarly, Chief Minister may be advising to the so-called the governor, and accordingly, the ordinance is being promulgated. Now, because of any reason, if this ordinance has failed to turn into a law, then ordinance is nullified. Then, if you want to re-promulgate the ordinance, is there any objection or restriction from the side of the Constitution? Answer is no. Constitution is silent with respect to the re-promulgation of ordinance. Right? So meaning is simple. The spirit with which they framed the Constitution, they might have thought that if this ordinance is not accepted, then the government will not think about this, and the government may be looking for some other alternative mechanisms. But those people did not think that the same ordinance will be re-promulgated again and again, again and again. So on one side, if you look at this particular situation, you are not violating anything under the Constitution, but undoubtedly you are violating the spirit of the Constitution. How? Basically, what will happen? Laws must be made by the legislatures. And those legislatures, whenever they are in the session, you are introducing the bill, discussing them, passing them, and making the laws. But otherwise, if it is an ordinance which is valid for a period of time, try to make it a permanent law at the earliest. But unfortunately, because there are oppositions from various political parties with respect to the ordinances, ordinances are not getting turned into the laws. That is the reason why the governments are trying to re-promulgate ordinances again and again. So now the Supreme Court felt very clearly that this is nothing but the violation of the spirit of the Constitution. This is nothing but a fraud on the on the Constitution. So under the Constitution, so this laws must be made only by democratically elected bodies, that is nothing but the parliament and the state legislatures. But what exactly you are doing? You are going in a wrong mechanism. Should it be questioned or not? Can the power of the president to remove promulgate ordinance, and can the power of the governor to re-promulgate the ordinance, can it be questioned or not? Meaning, are they subjected to judicial review or not? All these days, Constitution was silent on this, but now Supreme Court made it very, very clear that such a type of incidents will be coming under the purview of the judicial review. That's it. Clear with what intention? With what intention the president has re-promulgated? With what intention the governor has re-promulgated? That is subjected to judicial review. So this is the decision that has been given by the 7-judge constitutional bench, and 4 judges have given the judgment in favor of judicial review with respect to the ordinance making power of the president and governors, and 3 judges have given the judgment other way around. That is the reason why. So because the majority of 4 judges are supporting the questioning the ordinance, judicial review for the ordinance, now the ordinance will be coming under the purview of the judicial review. But what exactly happened? Bihar is one state in the country, so where during certain years, say for example 1971 to 1981, more ordinances were promulgated than passing the acts. So this is very, very unfortunate. And recently also, single ordinance was re-promulgated for 7 times. And when it was questioned in the Patna High Court made it very, very clear that re-promulgating ordinance so many number of times is invalid. You are not supposed to do that. Immediately, the state government has approached the Supreme Court. Supreme Court has constituted 7-judge bench, that is a seven-judge constitutional bench, and that judgment came out very recently, and they upheld the decision of the Patna High Court, and now the repromulgation of the ordinance by the president or the governor will be coming under the scanner, and the judicial review is very much permitted. Kindly see here, Supreme Court, as we know, Supreme Court is considered to be the final interpreter of the Constitution. That is the reason why, if you look at the Constitution, Article 123 or Article 213, they did not say anything about the repromulgation. But just because the Constitution did not say anything, can we do it? So during that time, you will have a doubt, and those doubts will be clarified by the Supreme Court. Of course, all constitutional questions can be challenged in the High Court and also in the Supreme Court. That is the reason why it went to High Court. High Court has made it very clear that you are not supposed to repromulgate again and again, and if you are doing so, that will be coming under the judicial review. All right, and later it has been challenged with the Supreme Court. As we know, Supreme Court is the final interpreter of the Constitution, and the judgment came very recently, and now their decisions with respect to ordinance for repromulgation, that will be coming under the purview of the judicial review. Am I clear? So kindly remember this one. Ordinance is a very common thing. So many times you might have heard about Article 123 and Article 213, right? So that is one side of the coin. But other side of the coin is that whether the court can interfere into the decision of the president or governor with respect to the ordinance making powers. Clear? All these days it was not clear. Now it is clear that the judicial review is very much permitted, because the judiciary, the highest judiciary, has pronounced its verdict. Am I clear? Very, very important one. Such type of issues will always play a very crucial role with respect to our examination. Kindly try to remember every point that I spoke to you. So now I'll show you the document where the Supreme Court has given certain statements, and now it is very clear that ordinance making power will be coming under the scanner of judicial review. Now I'll show you the document. Kindly have a look at this. Look at this. Repromulgation of ordinances without being placed before the legislature was constitutionally impermissible, as it amounted to bypassing legislative body, which was the primary source of lawmaking authority in a parliamentary democracy. We know that India is a democracy. India is a parliamentary democracy. In India, law-making authority lies with the legislatures. At the central level, the legislature is called the parliament. At the state level, the legislatures are called state legislatures. Am I clear? And if you want to repromulgate the ordinances without placing them before the parliament, without placing them before the state legislature, that is constitutionally impermissible. Right? Next. A 7-judge constitution bench, kindly remember, for the examination point of view, it was already a question in the examination. It was already a question in the examination in the year 2012 in UPSC. Minimum how many judges will be there in a constitution bench? Answer is 5. Minimum is 5. Okay, it may be 5, 7, 9, right? 11, 13. 13 was the maximum what we had so far. Clear? But otherwise, you know, this 5 will be there, 7 will be there. And the recent verdict was given by 7-judge bench. Kindly remember, these type of benches will be constituted always with the odd number. Always with odd number. It will become easy to decide it. If it is even number, what will happen? Say 6. 3 judges will support it, 3 judges will oppose it. 3 is equal to 3, then you cannot decide it. That's the reason why constitutional benches will always have the, minimum is 5, and you have the odd numbers, right? So that you can decide the majority, right? So now, so once again, I'll show you the document. Supreme Court is always, this is very, very interesting. And the statements that are given by the judges, so they are really, really very powerful, and they pierce into the so-called the government's powers. And India got a new CJI, you must be knowing, I was discussing, right? Kindly remember the name, right? A 7-judge constitution bench held that government's decision to bring ordinance can be reviewed by the judiciary, and said that it was obligatory on the part of the government to place the ordinance before the legislative body for its approval. It's an obligation for the government and to place that before the legislature. Kindly remember this one very clearly. Though Article 123 is giving the power to the president to promulgate the ordinance, in fact, the president is exercising every power only on the advice of the Council of Ministers headed by the Prime Minister. Right? In the similar manner, governor is also exercising the power under Article number 213 only on the advice of the Council of Ministers headed by the Chief Minister. Am I clear? And this is one of the fundamental principles in the so-called parliamentary democracy, and India is a parliamentary democracy. That's the reason why we call, president as de jure head, that is constitutional head. Governor is de jure head, constitutional head. Prime Minister, de facto head, real head. Right? Chief Minister, de facto head, real head. Right? Kindly remember these words. Now, failure of governments at the center as well as the states to place ordinances before the parliament and the state legislatures would itself constitute a fraud on the constitution. This is the statement used by the Honorable Supreme Court. If you are failed to place the ordinance before the state legislature or before the parliament, it would constitute a fraud on the constitution. The majority verdict held that repromulgation defeats the constitutional scheme under which a limited power to frame ordinances has been conferred on the president and the governor. Kindly remember this one. What do you mean by this statement? Governor and the president cannot issue the ordinances at any time they like. No. There is a limitation with respect to the power of the president and also on the power of the governor. They can promulgate the ordinances only when the parliament is under recess. Recess means parliament is not in the session. Only during that time they can do it. But with a condition, that particular one is valid only for a limited period of time. And whenever the parliament is summoned, on day number 1, it has to be introduced in the parliament, and from that date, it is valid for a period of 6 weeks. So within 6 weeks, if it is accepted by both Lok Sabha and Rajya Sabha, then the president will sign and it will become a permanent act. Meaning there is a procedure for making a temporary act as a permanent act. And if the parliament fails to approve this one, ordinance will become invalid. Am I clear? And again, the ordinance can be repromulgated, and that repromulgation power has been questioned now. That is what we have discussed so far. Meaning is simple. So the power of the president and the governor with respect to ordinance promulgation is limited, is restricted. Am I clear? Next. Look at this. Look at this. The danger of repromulgation lies in the threat which it poses to the sovereignty of the parliament and the state legislatures, which have been constituted as primary law givers under the constitution, meaning the primary organ to give the laws are the parliament and the state legislatures. Open legislative debate and discussion will provide sunshine which separates secrecy of ordinance making from transparent and accountable governance through the lawmaking. This is the statement that is given by the Supreme Court. Meaning, whenever you are making a, making an ordinance that is being made out of secrecy, once it is promulgated, then we'll come to know what exactly is the intention of the ordinance. And that ordinance has to be placed before the parliament, where openly the debate will take place, discussions will take place, deliberations will take place, and depending on the interest of the majority of people in the parliament and the state legislature, decision has to be taken. The Chief Justice, however, questioned whether it is mandatory for the government to place the ordinance before the legislative body, saying that the matter should be examined in a separate proceedings. Okay, but otherwise, there is another justice by name Justice Madan B. Lokur also deferred, stating that there could be situations, according to him, there could be situations, though very rare, right? There may be situations, but very rare, when repromulgation is necessary. This is the opinion of one of the judges, that is Justice Madan B. Lokar. But ultimately, what happened? Whatever the verdict that is given by the 4 judges, that is valid, and according to them, these ordinances will be coming under the purview of the judicial review, and the judiciary has every right to question that. I am clear? And this judgment is valid. This judgment is valid for a longer period of time, until and unless the parliament will make a separate law on this, or this judgment will be valid until and unless the Supreme Court gives a different verdict on similar type of case. Am I clear? So that is the reason why the judgments can be rewritten. But as of now, the repromulgation of the ordinances will be coming under the judicial review. Kindly remember, judiciary is important, parliament is also important. Functions of the judiciary, functions of the parliament, they are also very, very important. And remember, please, very clearly, the words judicial review are not mentioned in the constitution. Is that okay? Not mentioned in the constitution, but still, so we are following the concept, and because of that concept only, today the judiciary is trying to look into the various cases, and it is giving the various judgments, and the strength of the Supreme Court is increasing day by day, and the respect for the people towards the judiciary is increasing day by day, right? And that's all for the day, and I wish you all the very best, and thank you so much for being with me this evening. And one more news is that very soon very soon in 5 states elections are going to be held, right? And the schedule has been released by the election commission this evening, and if you are living in those states, that will be important for you. Please monitor how the elections are happening, and monitor very closely. Okay, so tomorrow, after you become an administrator, you need to perform these jobs, right? And I'll take leave of you now, and I'll see you tomorrow. So thank you so much. Take very good care of yourself. Good night.